Okay, so Rastaman is back in school. What is the story behind it? We go straight to our touch screen and we begin with the facts of the matter for you. The applicant, which is the Rastaman who went to court, is a 17-year-old who attended the Lord Shines International School and is a Rastafarian by religion. He wrote the BEC and passed with an aggregate of 6 and thus was placed in the school by the computer placement system. He went to the school and obtained the prospectus, all this while without being questioned about his hair, save on the day of reporting when a teacher asked him to step aside due to his dreadlocks. The assistant head teacher then asked that he cut his hair before being enrolled in Achimota school. The respondents, who are the other party to the case in this matter, that's how the lawyers call them, the respondents. The respondents, on the other hand, contend that the rules applied in Achimota are applied to every individual, notwithstanding the person's race, gender, or ethnicity. Hence, they ask him to stand aside. Hence, they asking him to stand aside was not due to his religious beliefs, but due to the rules that had been in existence for a long time, termed as H1, which provided that all mustaches, whiskers, beards, and hair should be trimmed short. Mustaches, whiskers, beards, and hair should be trimmed short. This rule was not targeted as a specific hairstyle, but for all students, notwithstanding their religious beliefs. This requirement was in line with the uniform of the school, which transcended clothing and included physical characteristics. So the school took the position that the hair thing is part of the school uniform. The school uniform is not just fabric, it is also appearance. That's the position that the school took. So we are proceeding. We are getting into court and getting into the mind of the judge. Okay, let's move on. So the first issue that we isolated as appeared before the court was an issue of capacity. Now, what does capacity mean? Capacity simply means does a person have a right to bring the matter before the court? So usually when the court checks... when the court sits in a civil matter, the first thing they check is the capacity of the individual. So if I'm suing on a land in Labadi, they ask, what is your capacity? Are you the Mankralo? Are you the Ulomo? You are not anything. You can bring an action into the court on a land in Labadi. But I can bring an action in the court in a land that my name is on it because I have capacity as the owner or joint owner, something like that. So capacity is the first matter that was discussed. Does the student have the right to bring that action in the court? Let's see what capacity, what each one said about capacity. The school, that is Achimota, argued that the applicant, the student, has no capacity to sue because he failed to fill and submit the acceptance form for the purpose of enrolling in the school. If this is so, then he cannot assert a right that is available to students. Non-discrimination, since he was never a student of the school. So it just says that Achimota School argued incapacity at the first instance, trying to disqualify the student from bringing the legal action, that he actually did not complete the forms to be a member of the school. So he has no right to sue as a member of the school. And then the judge said as follows, and we're going to read it. We'll finish very quickly, it's not that long, because we have isolated the important part out of the 28 pages. She said, I must reiterate that a person's right need not be breached to invoke the jurisdiction of the court under Article 33(1) of the 1992 Constitution. Once there is a threatened breach of the person's rights also, the cause of action is ripe. The provision is simple. That is, any person who alleges that his right has been or is being breached or is likely to be breached is capacitated to invoke the jurisdiction of this court. An allegation is one thing, the proof of the allegation is another. So that's how the judge interpreted it. The judge interpreted it, and I believe correctly, that in Article 33, it says that if a person thinks that his rights could be breached, he can bring them action to the High Court. So the students may not have registered with Achimota, but if he suspects, as he was told, that this is your Rasta head, once you register, we'll cut it. Then the applicant alleges or suspects that his right could be breached, he could come to the High Court so that the capacity was grounded. Okay, let's move on. The judge continues, in this case, I am satisfied that the refusal of the first respondent to accept the applicant's acceptance form, which the application contains a violation of his right. I am further satisfied per the facts that the allegation alleged that as alleged by the applicant, if such refusal threatens future breach of his rights, then he is constitutionally capacitated under 33. Okay, still on capacity. Now, there was another bit about discrimination, which we isolated for you to see. Discrimination. So it says, The applicant contends, and that's a young man who is contending. He sued through his father, by the way, because he's 17 years old. The applicant contends that the refusal to grant him admission amounts to discrimination against him on the grounds of his religious beliefs. That's what the Achimota boy is saying, that refusal to grant him admission is based on discrimination. The respondents, that's Achimota School, on the other hand, argue that the application of rules should be uniform on everyone and that the failure to apply it to everyone equally would amount to a discrimination against those who have decided to comply and cut their hair or who do not adhere to the faith of Rastafarianism. That's an interesting one, isn't it? So what it means is that on the subject of discrimination, both Achimota School and the young man had something to say. The young man said, I'm being discriminated against. They don't want me to go because they are discriminating against my religion. The school says what the young man is asking us to do is to discriminate against the rest of the students in his favor. We will not do that. So both parties talked about and complained about discrimination. Let's see what the judge said. The judge said it here, this on page 17 of the ruling. She said, and I quote, bluntly stated, what the respondents seem to suggest is that, the respondents being Achimota School, seem to suggest is that it matters not the mandate of the rules and the regulations of the school. Insofar as the rules are applicable to all students, then same is not discriminatory. This argument indeed appears consistent with the meaning of discrimination as regards the application of the school rules to all students in the school. The argument, however, this is a judge speaking, the argument, however, fails to properly situate and or balance the efficacy of the school rules as against the freedom of the applicant to practice and manifest the religion of Rastafarianism. Okay, that is, it is pertinent to consider whether the school rules, by its insistence that the applicant should cut his hair, which, as the applicant alleges, is how to manifest his religion, is a violation of the right to the religion of the applicant. It is to this that I turn. Then she continues on page 17. I have already resolved that any attempt to restrict a person from the enjoyment of that person's right to manifest and profess a religion must be gleaned from the very constitution that guaranteed that right. Indeed, it is in the public interest, she says, that people are able to manifest and profess their religious practices. We move on to still on page 17. At the same time, it is also in the public interest that proper rules and regulations are made to ensure discipline in our second cycle institutions. But, she says, can these rules be made to restrict the manifestation of the religion of another without legitimate or justifiable reasons? She says, I think not. Second paragraph on the page. While, as already pointed out, rules and regulations are essential to ordering discipline in schools, the rules must be consistent with the Constitution. Where the rule sins against the Constitution, where the rule sins against the constitutional guarantee of a person to practice and manifest any religion without legitimate justification, then, in my respectful view, same is unconstitutional. That is, any rule that prevents the person from practicing. Okay, to insist that a person should suspend the manifestation of his religion by cutting his dreadlocks before being enrolled in your institution, in my view, is clearly unconstitutional and sins against the Constitution 1992, if same is without reasonable justification. In other words, without any shadow of doubt, the Constitution allows for the restriction of fundamental human rights so long as there are justifiable grounds for the restriction. Now, this is very interesting. The second part of what she says is really where our critique is today. The second part of what she says. Let's read it. She says, if same is without reasonable justice. Okay, she says, in other words, comma, without any shadow of doubt, the Constitution allows for the restriction of fundamental human rights so long as there are justifiable grounds for it. But this is where we are at a total loss, because her lordship did not comment on the restrictions of the fundamental human rights in the Constitution. There are restrictions of fundamental human rights in the Constitution. There are restrictions that talk about education. There are restrictions of age. It's in Article 14.1. Unfortunately, her lordship wrote this on page 18. She says, in other words, without any shadow of doubt, the Constitution allows, yes, indeed, it allows for the restriction of fundamental human rights, so long as there are justifiable grounds for the restriction. She does not refer to the restrictions and then at least debunk those restrictions in the case of this case that is before her. She mentions the restrictions. She doesn't talk about them at all. We are going to point it out to her that the restrictions are such that it should have restricted her from giving the ruling that she gave. Okay, let's move on. Religious intolerance is undemocratic, she says. That's on page 20. Any state that fails to tolerate the practice and manifestations of religions of its citizens and people within the state portends a serious anarchy. Okay, we get that. Religious intolerance. Next one, she says, the said rule, that is the rule to cut your hair, must therefore be construed with the necessary subjection to the 1992 Constitution. I reject the argument of the Achimota school that this finding will amount to discriminating against the other students of the school who apparently have conformed to the rule without complaint. Rather, I hold the view that the rules and regulations of the school should only be viewed in the lens of the provisions of the Constitution to ensure that they do not sin against the people's rights to manifest and practice any religion they subscribe to, except on reasonable justification for the public good. Okay, let's move on. In that regard, Her Lordship says, school rules and regulations, though necessary for proper governing and the conduct of discipline of students, must not be applied in a manner that infringes on the rights of the students. Okay, let's move on. Now, justification of discrimination. That's our final and third theme. It says that the applicants noted that the rule H1 and H3, which compels the cutting of hair, can only be allowed if it is justifiable. That's the applicant, the student, that the rule to cut his hair is not justifiable. The respondents, on the other hand, argued that the requirement was necessary for the preservation of discipline in the school, that the requirement for the person to cut his hair was necessary for preserving school rules and discipline. The Rastaman also said that it is not justifiable. The restriction is not justifiable. Let's see what Her Lordship said. Her Lordship said that what will be the compelling disadvantage to the community of students if a student who states that he maintains dreadlocks in the practice and manifestation of his religious belief is permitted to maintain same in the school? He's asking a question. That what will happen? What will be the compelling disadvantage? Who is going to die? What's the disadvantage? If the guy wears dreadlocks in school, what's the problem? That's what she's asking. Can you imagine? Can you believe that? That's the question she's asking. Okay, let's move on. In answer to this question, the combined evidence of the respondents at Achimota School to the effect that the rules in issue is for the welfare of the students to maintain discipline, uniformity, and also hygiene amongst the students in the school. It is to be noted, this is the judge speaking, it is to be noted that the content of the said discipline, uniformity, and hygiene that results from the students keeping their hair low, simple, and natural has not been told to this court. So she's saying that Achimota School was unable to convince her and give her evidence that the maintenance of short hair will be in the interest of discipline, uniformity, and hygiene. She said Achimota School could not justify that. Where is the justification that if the hair is short, there will be it's hygienic? Where is the justification? That's the point she makes. Okay, all right. Further, it goes on. How the present state of hair of the applicant, the Rastaman, will impact negatively on his own educational good or those of the community of students has not been demonstrated to this court to weigh on the mind of the court to trump the constitutionally guaranteed right of the applicant for the public good or interest of the community of students. In the absence of such compelling justification grounded on the public good of the school as a whole, in the face of a constitutionally guaranteed right, I am unable to tip the balance in favor of the implementation of the rule of Achimota School to restrict the fundamental human right of the applicants to practice and manifest his religious beliefs. So that's the final one. That's the final one. Happily, we have done 15 minutes now. That's what she says. Okay. Let's quickly go to the Constitution, and then we will show why we believe that this ruling is bad and is wrong in the face of the Constitution 1992, that it was badly thought about. It's a wrong decision. We all agree with this, so the boys in school, but this is a wrong decision. It has to be tested and appeal. We believe that the three wise men at the Court of Appeal will have a different look at it. So this is the Constitution. Let's start with, should we start with Article 28? Yes. So let's start with Article 28. It's here. Children's rights. This is Article 28, yeah? Parliament shall enact such laws as are necessary to ensure that no child shall be deprived of any other, or no child shall be deprived by any other person of medical treatment, education, or any other social or economic benefit by reason only of religious or other beliefs. And then 5, that's 28:15. For the purposes of this article, child means a person below the age of 18 years. So that's clear, yeah. This is in favor of the Rastaman who went to court. This is in his favor. Let's look at it again. It says Parliament shall have power to announce that no child shall be deprived. You can't deprive a child of medical treatment, of education on the basis of religious belief. That's what the law says. So you cannot do that. Okay, let's move on. Let's come back to 14. Okay, so in 14 is this. These are the restrictions to the rights of people. All of us are rights. Religious rights, personal rights, everything. These are the restrictions, because there has to be restrictions. To every rule, there's an exception. So these are the exceptions to the restrictions in the Constitution, and we are surprised that Her Lordship did not even make any reference at all to it. She didn't say anything about Article 14. We are totally shocked that she didn't say anything about it. When she herself talked about the restrictions, she didn't say anything about this. Okay, let's move on. Let's look at it now. Every person shall be entitled to his personal liberty, and no person shall be deprived of his personal liberty except, these are the exceptions, except in the following cases and in accordance with the procedure permitted by law. Now, she herself made reference to the exceptions, and as we pointed out, she didn't talk about it, but these are the exceptions. So that's 14.1. And in the execution of a sentence, so that if you are found guilty of a court matter and they are going to execute you, you can't say that I have a right to live, so I have to live, because these are one of the exceptions to your right to live. So that's executions, and then court order. If the court says they should arrest you, you cannot claim and plea my right to freedom and all of that, because the court has said they should arrest you. These are the exceptions of the personal liberties, freedoms, religious freedoms, all of that. Let's look at the exception in D, the last one, 5, the exception in 5. Is it? Oh, sorry. Okay, the exception in E, I should say, yeah. Here it is. This is the other exception. It says, exception to your rights, which the judge didn't look at. For the purpose of the education or welfare of a person who has not attained the age of 18 years. That's very clear. Look at E. Viewers, you can see E. It says, for the purpose of the education or welfare of a person who has not attained the age of 18 years. I mean, this is quite straightforward, and I'm hearing tonight that the solicitors from the Attorney General's Department actually pointed this out to the judge. She completely ignored it. She didn't mention it in her ruling. It didn't appear anywhere. Totally ignored Article 14. I believe that if this is presented to the three wise men, as we call them, the Court of Appeal will definitely take a different view of the matter. For now, though, the guy is in school. It's good he has to be in school. If the appeal is won, which we suspect it will be won, and then he can then obey the school rules, so that we can have a country that develops on the basis of laws, because to every rule there's an exception. We have to leave it here. Holy Child are in the studio. But back to Achimota, Rastaman is in school.
From the father to Accra, from Riasa to guitar, we are brothers and our mother is a school. She will guide us all in each, so to learn that we may teach, so to subjugate ourselves that we may rule. Play the game, shout her name, spread her fame afar. She's the head of all the hosts, she's the school of whom we boast, she's the glory of the coast, Achimota.
Well, I told them we're going to come back here and they should look for good lawyers, because they have wounded an animal they cannot kill. And I said that because the assistant headmaster said they've had this case before the last year and the year before, and we could take it anywhere we wanted. So I told him, well, then they should look for good lawyers, because we are going to meet at the law court.
When our books are laid aside and we scatter far and wide, we remember with affection all we gained, how we learned to take a share in the life and labor there, where the men of whom we're proud and so were trained. Play the game, shout her name.
The mighty 1992 Constitution of our beloved country, Ghana, contains an entire chapter on fundamental rights and freedom.
I had no idea I would be telling one great story in the courtroom about how I was discriminated and how I am back, non-discriminated, because I'll be going back again because
They are manifesting their religion via the keeping of their hair. And so if they are supposed to come to school, they must come to school manifesting that religious faith and tenet.
What I would like the school to do is to give us a very warm reception and welcome so that the children can feel comfortable in being there.
I told you I shall be back, and we are back here.
I've been directed to be taken and admitted again at Achimota School.